Good morning, everyone, and thank you so much for joining us for our February webinar. As ever, we are live. For those of us joining us live, thank you very much. And for those of you who are watching us once the link is up on YouTube, again, thank you very much for joining us as well. Our February webinar is a focus on IR35, which was due to come into force in April 2020, but fast forward to 2021 and businesses are in the process of preparing themselves for its imminent implementation for private sector employers. Obviously, public sector employers, you've been used to IR35 for a while now. But what we wanted to do this morning was really focus on some of the key questions that we're being asked by our clients, but also key questions that some of you have emailed in advance as well. Absolutely thrilled this morning to be joined by Katie Harris, who's an associate within the team. Katie, this is our first time presenting a webinar together, so good morning.
It is. Good morning. Good morning, everyone.
Katie joined us in the summer of last year, so again, I'm really pleased to have Katie on the webinar with myself today. For those who don't know me, I'm Emma O'Connor, a Senior Associate in the Employment Team and Head of our HR Training Academy. Just a few housekeeping points. As I've said, we are live. What I will say is that this webinar isn't too much of a what is IR35. Katie and our colleague Barry Stanton did a What is IR35 webinar back in December, which is available on YouTube and on our website. And I will send out the link to that after this broadcast. But today's webinar is really much a focus on those high-level questions that we've had sent in. Please do send in your questions as well. As we said, this is your questions answered, so please do send those questions in via the chat panel. Katie and I will do our absolute best to sort of monitor those as we go through. Any that we can't answer, what we will do is we'll send out an FAQ after the broadcast. So again, please do send those questions in. So it's more of a focus on the key topics, the key questions, rather than what is IR35. Another couple of points just to say, we're focusing more on the client, so that end user, rather than contractor obligations. Obviously, we will pick up on some contractor obligations as we talk. And also to say that this is a tax issue and not a status issue. So IR35 is about tax and doesn't change anything, any of the rules or the laws with regards to employment or worker or self-employed status. So just to sort of pick up on that as well. Right, Katie, I said this wasn't a what is IR35, but of course my first question is, what are the new rules? So I think it'd be helpful just to have a little overview for people, just so we can kind of put today's webinar into context.
Yep, no, that's absolutely fine. So IR35 has been around since the year 2000, so it's not a new concept by any stretch. The whole idea behind IR35 is to ensure that people who are in fact working as employees are taxed as employees. And IR35 was introduced to tackle an increased use of personal services companies by consultants. Personal service company is essentially a consultant's own limited company through which they provide their services. And the way that IR35 works is that you ignore the fact that there is this personal services company, and you look at the relationship between the contractor and the client. Imagine that there would be a contract between the contractor and the client, and ask yourself whether the contractor is in fact working as an employee if that personal services company didn't exist. If the answer to that question is yes, then there is deemed employment, and the consultant then has to pay income tax and national insurance deductions on any fees that its personal services company receives for the services provided under that contract. Now, under the existing rules, the responsibility for identifying whether or not there's been deemed employment and for accounting for any tax sits with the consultant, who has to do that annually through their annual returns. Now, it's important to note that that concept of deemed employment and the way that the IR35 rules work isn't actually changing. The only thing that is changing from the 6th of April is the responsibility for identifying whether or not there is deemed employment and the responsibility for accounting for tax. The responsibility from April will now fall with the client, who has to undertake a determination to decide whether or not there is deemed employment. So the client will be the company who is in receipt of the consultant services. The responsibility for making tax deductions and paying any employer national insurance or apprenticeship levy payments, if those are due, sits with what is known as the fee payer. The fee payer is the organisation that pays the fees to the consultant's personal services company. So in many cases, the end client and the fee payer will be one and the same. So if we look at the first diagram on the slide that we have in front of us here, this shows a very simple supply chain where we have an end user client who's directly contracting with a personal services company. It is the end user client who has the responsibility to determine if there is deemed employment and also to make tax deductions. However, in many cases, the supply chain will be a little bit more complicated because the end user client may, in fact, engage in employment business or an employment agency to provide them with a consultant. And this is illustrated by the second diagram on this slide. And here you will see that the end user client has engaged with an agency for the consultant services. In this circumstance, the end user client has the responsibility for identifying whether or not there is deemed employment, but it is the employment business or agency that has the responsibility for accounting to HMRC for any income tax or national insurance payments due.
I think that's a really clear point, isn't it? There, I think that shift in tax liability to the end user client and the application of the IR35 is going to be a huge change. And certainly we're getting lots of queries, aren't we, from end user clients, so end users or clients, about exactly what they have to do. So, you know, that this is really going to make a big difference to the way in which organisations, end user clients use and contract with either agencies or personal service companies. And I guess the next point following on from this is really, well, what is a personal service company? Because it's not always straightforward, as we know. And how do I know if that contractor, that individual who is working within my organisation is working through a personal service company?
And Emma, I think that's a really, really good question, because this is something that actually isn't talked about a lot. The key to IR35 is that it will only apply where there is a personal service company. So it doesn't apply if you're contracting directly with the consultant themselves. There has to be a personal services company in the supply chain. And personal services company does actually have a very specific definition in the legislation. It is essentially a consultant's own limited company. The legislation defines this as a company in which the consultant has a material interest. And a material interest is the ownership of, or interest in, or control over 5% or more of the ordinary share capital in that company. So if the company that the client or fee payer is contracting with meets that definition, then it will be a personal services company and these rules will apply. Now, I've had some clients come to me and say, well, you know, how are we meant to know that the company we're contracting with is a personal service company and meets this criteria? Well, the good thing to know is that the legislation says that there is an obligation on the consultant to inform the fee payer, so whoever it is that is paying their fees, that could be the client or an employment business, that they are working through a personal services company. And if they do not provide this information, then the IR35 rules will apply by default, which means that the fee payer is required to make tax deductions unless and until the consultant says, actually, I'm not working through a PSC, and here are the reasons.
So if you've got an individual, so if you're just going back to sort of, I've contracted with an individual, so just to be clear on that, there may still be tax issues and status issues, but that's not IR35.
Yeah, that's absolutely right, Emma. Yeah, so it's just nothing has changed when you're contracting with an individual. You will still have the risk that if HMRC were to look at this and decide that that individual is in fact working as an employee for tax purposes, then you could still, as a business engaging with that in contract, to be liable for income tax, national insurance. But that has always been the case. That hasn't changed. Okay. And there is also, obviously, where there is that direct relationship between a company and a self-employed contractor, that there could be employment status issues for legal purposes as well. And that person could have acquired employment rights.
And we've just seen that with the new Uber decision as well. So those whole
absolutely, in the Supreme
really
Court,
live at the moment as well.
Absolutely, yeah.
And so the next question, and this is one that we were sent in advance, so thank you very much for that. But really looking at this end user, so the client, these client businesses, who is going to be caught by these new rules, Katie?
So again, another good question, and this may be something that many listening may already be aware of, but the new rules don't apply to all clients, all businesses. So the end user client will only be caught by these rules if they are medium or large. So an end user client will be considered medium or large if they meet 2 of the 3 tests set out here on this slide. So that is turnover of 10.1 million or greater, greater than 5.1 million gross assets, and fewer than 50 employees in the relevant financial, in any financial year. Now, when we're looking at this test, and this is again something that isn't talked about in great length, or many people don't go into a lot of detail about it, but it's important to note when you're applying this test, it will, and your company, the end user client, is part of a larger group, that it is the aggregate figures of the entire group that you apply to that company. And that is the case even if one of the members of that group is based overseas. So even if you're in a smaller company that does not meet those 3 criteria, but you are part of a larger group, then it is likely that you will still be caught by this if the aggregated group's figures meet that criteria. The other thing I want to say is that the criteria will only apply if the company has met 2 of those criteria for the last 2 consecutive financial years. So you're not just looking at 1 financial year, you have to look at 2 consecutive financial years. And for the purposes of the tax year, so from this April, 6th of April 2021 onwards, the first financial year that you go back to is your sort of year ending immediately before the start of this tax year. So for example, if you're a company and your financial year ends in December 2020, it is that financial year that you have to go back to, and then the year before it, so 2 years before that, when you're applying this test. And then the final point I want to make on this is that when we're looking at the number of employees, and we have to take an average of the number of employees employed during the course of the relevant financial year. So how you're meant to do that is you look at the number of employees employed each month, you total that up, and then divide it by 12 to find the average number of employees in that financial year.
Okay, thank you. And the next point is really looking at those dates again, isn't it? Because I think dates are always sort of crucial in these types of scenarios, particularly where you've got different, financial years and tax years. So our next question is looking at, if I have a contractor who is working prior to the 6th of April 2021, but is paid for the work after April 2021, will the new rules apply to the payment? So is it the date the contractor is working, or the date of payment that's important in this scenario?
Yeah, so again, this is another really, really good question. And this is actually something that I've seen different answers to, believe it or not, in different publications. And I think there certainly was some confusion about this when the rules were initially published. But HMRC has updated its guidance in the last 6 months to clarify that the new rules will only apply where both the payment and the services occur after the 6th of April. So if, for example, you are making a payment to a consultant in respect of services that they performed before the 6th of April, then that payment is not caught by the new rules. You may find that you have a situation where you have a consultant who has worked before the 6th of April, and you are making a payment to them after the 6th of April, which is for services that were provided both before the 6th of April and after the 6th of April. So you have one payment for services that cover both sides of the fence, if you like. And what HMRC says that you must do in those circumstances is pro rata the tax deductions in a sensible way. So you have to find a sensible way of identifying what part of that payment related to services post 6th of April and applied tax deductions, if of course you need to only that part of the payment.
Okay, so really focus on those dates and really look at when the services are being provided and when the payment is being made. And you know, the pro-ratering, will businesses be expected then to sort of keep records of how they've prorated?
Yeah, I mean, it would definitely, I mean, there's nothing in the legislation that says specifically you have to keep records, but obviously if you're audited or HMRC question this, it would be sensible to have some documentation or some records to help you explain why you have prorated that tax in a particular way. So, for instance, many consultants will be providing invoices which break down the days on which they provided their services, perhaps with a daily rate. If you're able to, you know, demonstrate quite clearly in your records that certain fees or a certain value of fees can be attributed to particular dates, then that will obviously be helpful.
Excellent, thank you. Right, let's get down to the nuts and bolts now. If we've been through all our tests and we are caught by these changes, what do we have to do?
So yeah, I mean, this really is the $1 million question, isn't it? And your responsibilities will vary depending on whether or not you are an end user client or you are just a fee payer, for instance, because you're an employment business or an employment agency. Obviously, if you're a client, as I've already explained, you will have the sole responsibility for all of it. But if you are a client, your responsibility will always be to determine whether or not there is deemed employment. And the way you do that is by producing what is known as a status determination statement. This has to be a written statement which sets out what that determination is, i.e. is there deemed employment or not, and which sets out clear reasons for why that decision has been reached. That status determination statement, which I'll refer to as SDS because it's a lot easier on the tongue, has to be provided for consultants who are already engaged on services before the 6th of April, or for consultants who commence work after the 6th of April, it has to be provided before the services commence. The other requirement for the SDS is that it must be undertaken with reasonable care. Now, once you make your SDS, the end user client is required to pass a copy of the SDS to both the consultant and also to the next party in the supply chain, if there is one. So in the diagram that I have here, we have a typical labour supply chain where the end user client is using an employment business or agency to supply the consultant to them. In this example, the end user client will have to provide a copy of the SDS both to the consultant and also to the end users, employment business who is next in line. If the end user client is also the fee payer, then they will also be responsible for accounting for any tax and national insurance payments due. If you are an employment business, then you are the fee payer, so you are paying the consultant's personal services company, then you have the responsibility for passing a copy of the SDS to the consultant's PSC or to another employment business in the agency if there is another one sitting between you and the consultant. And if necessary, making income tax and national insurance deductions, in addition to paying employers' national insurance, which at the moment is at a rate of 13.8%, and any apprenticeship levy payments that may be due.
So I think, we can't stress enough how important that SDS document is going to be.
Absolutely.
And forgive me if we're going to talk about this later, but the end user client, can you imagine scenarios where the end user client will undertake the assessment, and we will talk about how we do that, but can you see scenarios where the end user client passes it then to the agency, but then the agency doesn't pass it down the supply chain? So is there a responsibility on the end user client to ensure that the agency passes it on?
So and answer that question, and yes, I think there is a question later on that will deal with this, but essentially the end user client's responsibilities where there is an agency is purely to undertake the SDS, make sure it's in writing and has reasons, that it's taken with reasonable care, and to pass that to the employment business. Provided it has done all of that, then it has satisfied its obligations under the legislation. If then the employment business fails to do their bit, so they either fail to pass that on themselves or they fail to account for any tax, then they will be the ones that are liable potentially for any fees, interest, penalties that might be imposed by HMRC for any failure to account for any tax that may occur as a result. And one of the things, Emma, I think that might be worth mentioning here as well is this requirement to take reasonable care. And taking reasonable care, HMRC has now given some sort of fairly helpful guidance on what this looks like. But essentially, end user clients are obliged to make sure that they are training the individuals who are undertaking these SDSs so that they know and fully understand the correct tests that they need to apply to establish whether or not there's deemed employment status. They need to understand the information that they need to gather from the consultant and from the business in order to be able to make that determination. They need to be looking at each engagement on a case-by-case basis. They should not be making blanket determinations. They need to look at things at an individual level. And making sure there are proper processes in place to ensure that the SDS remains up to date. So, if the client fails to take all of those steps, then liability will potentially still rest with them. So it is really important that we get this, end user clients get this right when making these SDSs.
No, absolutely. And obviously we talked about this deemed employment. So this SDS is determining whether there is deemed employment between the end user and obviously the eventual worker, as we can see there. And our next question really asks what assistance is there? So how can end users undertake the SDS and what is this test for deemed employment status?
Yeah, so it's a really big ask that for end user clients, because employment status, as I'm sure many people listening now will know, has been a heavily litigated area. The Uber case, the recent Supreme Court decision, just goes further to illustrate that. So it is a very, very complex test. And unfortunately, there are no easy answers for it. And actually, we could have an entire session just on this one topic, which we don't have time for, obviously. But in broad terms, there are essentially 4 key elements that you are looking for. And the first of these is whether or not there is mutuality of obligation. This is an obligation on the client to offer work and on the consultant to have to undertake work if it's offered or provided. Personal service, which is the requirement on the consultant to personally undertake that work. And this is where debates regarding substitution clauses and things like that are relevant. They come into this requirement of personal service. Control, so this is the master-servant type relationship. How much control does the end user client have over how, when and where the consultant provides their services? And finally, this other factors element. Now, this is something that has actually been gaining increasing importance over sort of the last couple of years in case law. And this is where you have to look at the relationship as a whole and, consider whether there are other factors either consistent or inconsistent with employment status. Now, when looking at somebody who is self-employed, what HMRC are really looking for is to see whether that individual can truly be said to be in business on their own account. And so this would look at things like how much financial risk is the consultant taking? Do they have to invest in their business by buying their own equipment or invest in marketing costs? Things like that? Do they have an opportunity to profit? Are they marketing their services to the world at large? Do they have a website? Do they have many other clients? All those sorts of things. Now, I think there's 2 important points to mention here. The first off is that the terms of the contract are not determinative on themselves. HMRC and the courts will and often do, and in fact did in the Uber case, look beyond the terms of the contract to see how the relationship is operating in practice. So when you're looking at your SDS, it is really important that you undertake an information gathering exercise into the relationship itself. How is it managed within the business? How will the business engage with this consultant on a day-to-day basis? And you should not confine yourself to just looking at the contract. Otherwise, that is likely to be a failure to take reasonable care. The other point is that the test is holistic, and this is something that courts have been very keen to stress recently. There isn't a tick box, one size fits all approach that you can take. And this is why this has been so heavily litigated. You have to stand back and look at the contract as a whole and decide on balance whether it is more likely the person is in deemed employment or not. Now, there are lots of tools out there for clients. The one that probably you've all most heard about is the CESS tool, which stands for the Check Employment Status tool. This is HMRC's own tool, which they have much lauded as being this wonderful instrument to help and assist clients and make the SDS process so much easier. It is good. HMRC have said that they will stand by any CESS output. However, that is heavily caveated on the basis that the client has to make sure they input the right information and use the CESS tool in the right way. But if you can use a CESS output as an SDS. The problem with CESS is that it has been heavily criticised. It's limited. It doesn't take into account mutuality of obligation, which is obviously one of the key tests, and isn't always in every contract. And it also does take this tick box approach, which the courts have criticised and said, you know, you can't use that. Finally, CEST, and some of you listening may have already experienced this, quite often will come out with an indeterminate response. So it will literally say, sorry, we don't know the answer. We can't tell you whether this person's in deemed employment or not, which isn't helpful and will leave clients stuck. Other alternatives, professional advisors, so employment lawyers like myself, accountants, people who understand the employment status and the application of these rules will be able to perhaps undertake SDSs on your behalf, or at least give you guidance around the test to be applied. There are also a number of third-party organisations who also offer this service. But a word of warning, HMRC have made it very, very clear that if you use a third party to undertake SDSs on your behalf, the end client will still maintain the responsibility for ensuring that these have been undertaken with reasonable care. Finally, training. Make sure that your individuals in your organisation are properly trained. We at Boyce Turner can offer that training to your organisation.
Absolutely. I think, you know, that training for your individuals who will be undertaking these assessments and these reviews, to really stress, and again, you know, just to really stress the point that when we talk about status, whether it's tax status or employment status, it really is the reality of the relationship. And you know, you can have you can have the tightest set of terms and conditions, but if that individual is working as a de facto employee, they're sitting there, they've worked with you for a number of years, they only work for you, they've got an email address, they've got a company phone, laptop, they're treated as part of the furniture, then, you know, as I said, your contract is really, you know, not worth the paper. And also now, you know, looking at some of the cases, particularly with sort of the Uber decision, you know, the sophistication now of things like apps and contactability, and again, you know, it's almost like the law is trying to catch up with the reality of how people are working and the sophisticated ways in which people work. So really do be alive to that.
Yeah.
We've had a couple of questions, Katie, and it's probably we'll talk about those now as we're talking about CEST and obviously the SDSs. So Keely has asked, how often should organisations, so end users, be undertaking the SDS?
Okay, that's a really good question. So thank you for asking that. So an SDS has to be carried out at the commencement of the services, always. But in addition, the SDS must also be undertaken any time that there is a change in the way in which those services are being provided. So is there a change in the way in which the consultant is engaging with the business? Perhaps there's a change in hours, perhaps there's a change in the amount of control that the consultant or the business might have over the consultant. You know, there are all sorts of factors where that relationship could change in a way that might impact upon the SDS. So really, any time that there is a change in the nature of the relationship and the way that those services are being provided should prompt another or at least a review of the existing SDS. And also every time, you know, that the consultant moves on to a new contract, so maybe you've got the same consultant undertaking the same services, perhaps it was on a fixed term, we're going to put them on a new contract, we would do the SDS again then. So in answer to your question about, is there a particular time frame? Well, not really, because it depends on each individual case and how frequently the relationship between the business and the consultant may change. But I think having a regular process in place for regular review periods would be a very sensible thing to do. How long you leave it between those review periods will probably depend on your business, how fast moving it is, and how long the contract is as well. But I would say probably at least every few months to every 6 months.
I think the other point there, and you've hit the nail on the head, is the process point, because it might be that the individual who has undertaken the SDS is not the person on the ground seeing how things are working.
Yes.
So again, we will talk about this. It's about having that chain of command and being able to have those processes in place that will allow this, for the SDSs to be reviewed. So no set time, clearly, it's going to be fact specific, contract specific, but really will depend on what's going to be important is having those processes. We've had another question, and it might be one that I think Anonymous will come back to you on that, because I think it's a specific one. So we will have a look at it. We'll come back to you on that one. Eleanor, thank you. Kate, we've got a question here. Does the SDS apply to all contracts / engagements where the client meets the requirements? So I guess, is it contract specific or contractor specific?
Okay, so I think what we want to know is, if we have a client who is a medium or a large client and they're engaging with a contractor through a personal services company, so all the other elements are ticked, whether there are circumstances in which nevertheless these rules might not apply. I think that's the question. If it isn't, I apologise. The answer to that is that there are some engagements or some contracts that fall outside of these rules. And this relates to contracted out services, which again is something that I haven't seen talked about a lot in articles on this topic. It is very, very complicated. I shall sort of try and provide a high level overview of it. Essentially, a contracted out service is where you as a company have a contract in place with another company for the provision of a service. Now, you may have, as part of that contract, a consultant providing services to you, the client, through their personal services company. But if your contract with the service provider is purely for the services, so you are paying a fee for the services that is not attached to a particular individual contractor, and you are not paying fees that are directly related to that individual contractor's hourly or daily rate. So a typical example I had this morning would be, we have a client has a contract for the provision of project services, and the service provider supplies 2 or 3 different consultants to provide project services as part of that contract. But the client is paying an overall fee for project services and is uninterested which contractor will turn up to perform that work. Then that is likely to be a contracted out service. And so the new rules would not apply to that particular contract. So your contract as the client, so between you as the client and the service provider. However, if the contract relates to a particular named consultant, and the fee that you are paying is for that particular consultant's time, then it wouldn't be a contracted out service and would more likely fall within these rules. So it is very complicated. It's not very easy sometimes to identify whether something is or is not a contracted out service. HMRC do have some helpful examples to illustrate it. But what I would say is, if you have any uncertainty over your particular situation, that you seek advice on that. So I hope that answers the question. Absolutely. It's very complicated, but
no, that's a really useful point, because I think a lot of end users will be thinking, hang on a minute, I have a contract, as you said, contract of services, where yes, I do have an agency, but we have lots of people coming in to do do project work for us. Does that mean I've got to do an SDS for exactly. The 50 or so people? So that's really useful. But again, as Katie said, if it's if you're unsure whether your contract would fall within these changes or not, then do take advice. Julie, I will answer this one for you. So just so you are clear, the SDS, the status determination statement, is something that all end users, all clients have to undertake. So it's a paper exercise. It's a review exercise. And you have to do that whether you are whether you're using an agency or you're paying the fee yourself. So SDS is the process for determining the status of the worker. CEST, CEST, is a tool, is a government tool that is available on the gov.uk website that you can use to help you make that assessment, to help you do your SDS. It's not brilliant, it's not perfect, not foolproof. It doesn't mean that you're not liable if you've got something wrong, but it is a method, it is a tool. Okay, so hopefully, Julie, that's helped you out there. Rebecca has asked, if we are a small company, so a small business, and so we're not caught by any of the the rules we've discussed, do we have to do anything? Do you have to notify HMRC that this doesn't apply to us?
No, and that's a really good question again. So thank you very much for asking it. So if you're a small business and so you don't have to comply with these new rules, you don't have to do anything. You don't have to worry about it. But I think it is worth making the point that the existing IR35 regime, where the responsibility sits with the consultant to put their hand up at the end of every tax year and tell HMRC, if they owe them any income tax, that is staying the same. So that will still be there. But the responsibility is on the consultant to do that, not on you as the client, and not on any employment business. So hopefully that answers that question.
But it's still worth, in those situations, as you said, if you're not caught by the change to the assessment for IR35, it's still really important. Keep those contractor relationships under review. Make sure that somebody does not become part of the furniture, because we're not just talking about tax here. We are also talking about the risk of employment status as well. So even though you're not caught by IR35, it's still really important to keep those contractor relationships under review. Okay, I'm going to move on to the next question, because I'm thinking that we might be able to answer some of those as we go on.
Okay.
Right. I think this will actually answer a couple of questions that we've had through about obviously we do our STS and we use the CEF tool or whatever tool that we are using. And we send the SDS to either the agency or the contractor, depending on the way our supply chain works. What's going to happen if there is disagreement over what we have said, Katie?
Yeah. So again, this is something that I expect we're going to see probably quite a few very unhappy contractors who, if they are found to be
going to be a big issue, isn't it?
Oh yeah, no, absolutely.
It's potentially going to be a big issue, isn't it?
Yeah.
Financially for a contractor, if they've been used to be treated as a contractor, to all of a sudden to now have to have, and also the fact that either the agency or the end user is going to deduct the money at source. They're not going to do it, themselves anymore. It's going to be a huge issue, isn't it, for contractors potentially here?
Absolutely, it is. And I've already spoken to lots of clients who are having to have some very difficult conversations with their contractors. Mm-hmm. Now, I mean, in the rules there is a provision for what the contractor can do if they're not happy with the status determination statement. And it's called the client-led disagreement process. Now, unfortunately, the legislation isn't very clear on the specifics of what this process should look like, which is helpful in some degree because it does mean that clients have some discretion there to decide what the process should look like for them. But essentially, what it says is that the consultant can make representations to say that they are unhappy with their statement. It doesn't say how those representations have to be made, so they can be made verbally or in writing. And the legislation also does not say who they have to be made to. So they can, and in most cases, if there is an employment business, probably will be made to the employment business, for instance. But nevertheless, once the consultant has made representations that they are unhappy, the client must provide a written response to those representations within 45 days from when the client, receive the representation. So that could be a telephone call from the employment business to say our contractor is not very happy, or it could be an email from the contractor themselves. Either way, those 45 days will start to run from the date on which the client receives the complaint, essentially. And the client has two options. It can either uphold the original SDS, but if it does so, it has to provide its reasons for doing that, again, in writing. Or it can issue an entirely new SDS and withdraw the previous one. So it can decide, actually, okay, we did make an error, or we've taken into account these new facts, and so we're going to issue a new SDS with a different decision. Either way, it must be in writing. Failure to comply with this by the client can lead to tax liability remaining with the client. So again, it is really, really important to make sure that you have proper processes in place for dealing with this client-led disagreement process. Options open to clients if you've got some very unhappy contractors who are inside IR35. Very limited, unfortunately. I've set out some options on this side here. You can look to bring them onto the payroll and engage them as employees or workers. Obviously, that's going to still create a cost, an increased cost for you as a client, and won't satisfy probably the consultant in terms of the reduction in their fees. But it may be palatable because consultants will then be entitled to benefits they might not otherwise have had, such as holiday pay, pension entitlement, and you as a client will have more of an ability to control what they do. So it could be an option for some organisations. You can offer to increase the consultant's fees to try and provide a cushion to the impact that the tax deductions will have. You could also require your consultant to go through an employment business or an agency. And the benefit of that to you as an end client will mean that you won't have the responsibility for making those tax deductions or incurring that cost of 13.8% for the employer national insurance payments. It doesn't help the contractor, obviously, but it will help you potentially as an end user client. You could engage directly with consultants themselves individually, i.e. not through their personal services company. And if you were to do that, you don't have to worry about undertaking SDSs because these rules would not apply. However, as we have already pointed out, there will be a significant risk of normal income tax rules applying, as well as employment status risks. And if you've done this deliberately to avoid having to make income tax deductions, then that is not going to be looked upon very fondly by HMRC. So you are very much at risk of high penalties for doing that. Finally, you could look to outsource the work to a service provider potentially. One option, if you've got consultants who are very, very valuable to you, who you want to keep happy, and where you have some degree of commercial flexibility in relation to the arrangements you have with that consultant, is you could look to see whether there was a way you can restructure your relationship and the way that those services are provided so that they are more likely to fall outside of IR35. But again, that option won't be suitable for everybody.
And I suppose that brings us really neatly on to what happens if the client or the employment business or the agency fails to comply with the new rules. What are the potential penalties that we're looking at here, Katie?
Yeah, so I think we've obviously what happens will look depending on the type of stuff. We've got different failures here. So we've got a failure by the client would be a failure to pass on the SDS, as we've explained, a failure to take reasonable care when producing the SDS, or to properly deal with the client-led disagreement process. And if you're an agency, your failure might be to pass on that SDS or account for any tax and national insurance. Again, if you're a client who is also the fee payer, you would be there would be a failure there if you failed to account for any tax or national insurance as well. How the rules work is that where there is a failure, so let's say there is a failure by the client to either pass on the SDS or undertake reasonable care with it, the liability to account to HMRC for any income tax and national insurance would actually stay with that client. And this would be the case even if the employment business had been making tax deductions. And how HMRC would deal with that is that they would reconcile the situation by refunding the the tax to the employment business and seeking to recover that from you as the client. And again, that's the same if you are the employment business. If you have failed to pass the SDS on, perhaps to another employment business in the chain, then you will also be responsible for that liability. There are fees that can be imposed as well, as I've just mentioned. HMRC have said just very recently in the last week or so that they will take a light touch approach towards penalties for the first 12 months. So what that means is that they won't look to impose penalties where there's been a genuine error, and they will look instead to work with the organisation. But where there has been deliberate avoidance, they will still look to impose those penalties. And finally, it's important to be aware that if any organisation in that supply chain becomes insolvent or HMRC are otherwise unable to recover income tax from them, HMRC does have the power to go to other organisations higher up in the supply chain. So if you are a client and you're engaging with an employment business and that employment business becomes insolvent, you, the client, could potentially be on the hook for any income tax and national insurance payments due.
Wow, that's a really important point, isn't it?
Yeah.
That the sort of going up the supply chain. So, you know, it's these rules, this rule change and this passing of liability could potentially have huge impacts, not just for consultants and contractors, but obviously for our end user clients as well. I'm sort of, you know, thinking on top of my head. I mean, a lot of queries and questions for HMRC, isn't it, as well? And I'm just, you know, a lot of work for them in terms of, you know, getting involved. Yes, I'm just wondering if they've got the manpower to be able to sort of handle these questions that are thrown at them.
Absolutely, it's a very good question, but this is actually one of the reasons for shifting the responsibility onto end user clients. Because if you imagine in the past, when the responsibility was on the individual consultants' PSCs, that was huge amounts of work for HMRC to have to try and audit. You know, if you think of all the many thousands of PSCs there must be in the country, whereas now all HMRC has to do is go to one client who may be engaging with many different PSCs. So that does help HMRC in terms of enforcing compliance. But otherwise, yeah, I mean, you know, I think HMRC have indicated that they will be approaching clients in particular high-risk industries, such as perhaps the IT industry or financial services, where there is a high use of personal services companies and consultants, and will be making supportive phone calls to check with that organisation's compliance and make sure that they're doing everything correctly. So there is an indication that HMRC will be being quite proactive with this, but how proactive they are actually going to be remains to be seen.
Yeah, it'd be interesting to see, isn't it, moving forward, particularly with you know, this is obviously straddling the furlough scheme, which obviously we expect to be extended as well. So again, that's still being administered by HMRC. So it's going to be interesting to see actually how much time HMRC have got to refocus on this. But we've talked about obviously what the changes are, what implications that's going to be for end user clients, and obviously what happens when you've got different people's supply chain. What at this point, you know, when we've still got some time available, what practical steps should our end user clients be taking to get ready for this, to get ready for IR35?
Yeah, so there are lots of steps that can be taken, and I think what I want to point out at this stage is that this is by no means an easy feat to get ready and to be prepared. Particularly if you're in work for a business who engages with a number of different contractors. There is actually quite a lot of work to do. So don't underestimate the amount of preparation that you may need to do on this. And really the first thing that as a business you want to be looking at is to understand your supply chain, your labour supply chain. You need to understand who you're contracting with and what you've got, essentially. So you need to be looking at your contractor population, identifying any of those that might be working through personal services companies, looking at where you use employment businesses, understanding whether any of the consultants that are being supplied to you through employment businesses are engaged via personal services companies. You also want to be looking at doing your due diligence on the third parties, such as employment businesses that you are using to obtain your consultants, for the very reasons that I've just mentioned. Because, you know, if this third party employment business were to become insolvent, or for any other reason were to fail to pay any tax due, that liability is likely to fall back onto the end user clients. So end user clients are really, it's really important that they make sure that that anyone that they're doing business with, or any employment businesses they're contracting with, are sound, solid, trustworthy organisations. The second thing that businesses need to be thinking about once they understand their labour supply chain and they've identified those contracts which are likely to fall within these new rules, is to then review the terms, the contractual terms that they have in place, both with their contractors and also with any employment businesses that they engage with. Obviously, there is financial risk. There are processes that need to be followed. So it is important to make sure that your contractual terms reflect your obligations under the new rules, and in particular with any contracts that you have with consultants, that you, if you are also going to be a fee payer, i.e. they have the responsibility for deducting income tax and national insurance payments, that you have the contractual right to make those deductions in your contracts. And finally, and this is a point that we've laboured quite a lot on already, it is really important for you to put clear processes in place for undertaking SDSs, dealing with any contractor complaints, and also for reviewing those SDSs throughout the life cycle of an agreement. What you don't want is for managers in your business who may have the responsibility for engaging consultants to be going off on a tangent and undertaking SDSs themselves and not really applying the correct rules, and the business having no real oversight or visibility about what is going on and who is doing what. That is likely to amount to a failure to take reasonable care, which could leave your business liable. What you do want is to have specific named individuals having the responsibility for undertaking SDSs, who are properly trained, that there is a clear process in place for information gathering so that those SDSs can be undertaken, and that you've got that review process in place, as well, as I think we mentioned earlier in response to that question. So there is
Absolutely.
a lot of work to be done.
Consistency, isn't it?
Yeah, a need. Yeah, absolutely. a need for consistency, and a need for, I think, a streamlined process which is very well controlled, I would say, to make sure that you get this right.
I'm conscious that we're sort of reaching the end of our hour, but Katie and I did want to share with you, obviously, what we are doing with clients and how we're helping them, just to show you what support is out there, and obviously what support we can give to your organisation, particularly if you're that end user client, around your terms and conditions and your SDSs, but also for employment businesses as well. And I think that's another key sector that will need some assistance on this. So really what we're looking at, Katie, is that help, aren't we? That help, that due diligence process that we've talked about, that auditing. Who have you got? What have you got? What do they do and how do they do it?
Exactly.
We've then got that point about the SDSs, because that's really going to be the most crucial, isn't it, of the the sort of the processes. So again, we can help with that. We can help with the drafting. We can help with the preparation. for you to do it on your behalf as well. And I think the other really important point there that you've talked about, Katie, is obviously the training, because you know, this person does need, whoever is undertaking will need training in how to undertake this SDS review. So again, get in touch. Also, if you are interested in joining a session, if I've got individuals who want to come along and want to join a training session, then we will run one, and we'll run one for people who can come, you want to sort of join. So, you know, do put it in your feedback form if you're interested in coming along to a training session on that, because, you know, we want to run sessions that people want to come to. And contractor disputes as well, Katie, we've got that written down, haven't we? Something that we can do. Because as we've said, I think that's going to be a big issue, particularly where clients and end users are going to be cautious, aren't they? Because, you know, effectively, you know, this is a big deal for them and a big potential tax liability. So again, you know, some help and assistance there. And I can see my questions pinging as we go. Anonymous, you've sent me quite a few questions. I'm not sure if your name is anonymous on the feedback form, but if you could let me know who you are, and we will come back to you separately, because you've asked me one quick question just before we go. Again, Julie has asked, we have a number of freelancers who provide articles for our magazine. Do we need to do an SDS for them too? But I guess the point there is, it depends how they're working, isn't it? If they're working as individuals, then no, but you know, obviously there are other issues that we need to be worried about. If they are working through either an agency or their own personal service company, then yes, you do, unless you can argue that you've contracted out the service. We can't tell on that basis.
I think just to clarify on that point, is that I think it's unlikely to be contract out service where you've got one person who's providing a particular service to you. So I think that's unlikely to apply. But the rules will only apply if there's a personal services company there. So even if you're going through an agency, it depends how the agency is contracting Absolutely. With the contractor. So if the agency has a contract with a personal services company, then the rules apply. But if the agency has engaged them as a normal individual agency worker, then the rules do not apply.
Yeah, let me just
so it's only if there's a personal services company. Yeah,
absolutely. So I think Julie, for that one, it's going back to that point. Know who you've got, what they're doing, and how they do it, and who they do it through. Because once you've gone through stage one of the process, that's really going to help you work out exactly who's caught, where, and why. So again, there's the slide there with the, you know, with how your process may work. You may have another agency involved, but really the focus is on that personal service company that the individual is working through. So thank you so much, Katie, for taking us through all of that. And I think it's going to be a huge issue for clients, for organisations, but also for contractors and employment businesses as well. And we've certainly seen an uptake in questions that we are being asked, and certainly situations we're being asked to get involved in. You will get a feedback form at the end. So again, if you want to hear more, if you want to come and join us for a training session, if you want some individual help with those SDSs and how we can get those processes in place, which I think are going to be so crucial in this, then do please pop it on your feedback form. It's been really great to have so many of you joining us today live. It's really great. So thank you so much for supporting our webinar program as well. Katie, thank you. Go and have a drink of water. And I look very much forward to seeing you all again on our next webinar as well. So thank you again, and we will hopefully see you soon. Thank you so much. Bye-bye.
Thanks, everyone. Bye-bye.
Bye-bye.